Okay, folks, my name is Doug Pinkham. I'm with Pinkham and Associates. We are a dedicated family law firm in Orange County, California. But we are helping you fill out your forms in this particular video to help with this. This form has several applications, and I'll discuss those in a minute. This is the FL-157. It is called the Spousal or Partner Support Declaration Attachment. And as I said, this FL-157 is used for many different things in the family court. You're going to fill out and use this form at any time that you are doing a request for attorney's fees. Obviously, you're going to use this when you're asking for spousal support. And there's a couple other applications, but you will know if you need the FL-157, and let me explain it in detail as we go through it. So, all right. The first question right at the top there, you're going to mark a box to tell the court what you're doing and what you're attaching this form to. It needs to be part of supplementing another form. Now, is it part of a declaration for default or uncontested judgment? Or is it part of supporting declaration for attorney's fees and costs? And the other box, you could mark that and put in there that you are asking for spousal support. It's part of a spousal support request. I can't even begin to imagine why a spousal or partner support declaration attachment would not have a box that's already marked for a request for spousal support, but it does not, and they are going to make that change, I'm certain, soon. But as for now, just mark other, and next to where it says specify, put in there requests for spousal support. It will be enough. That'll be fine. Okay, number one, spousal or domestic partner support. I request that the court, and you're supposed to check all the boxes that apply, enter a judgment for spousal or domestic partner support and you're going to mark if you want to receive spousal support and you're the petitioner, you would mark A, and petitioner if you are doing this as part of a judgment. If you're filling out this form and submitting it as part of a judgment, that's A. And again, if you're the respondent and you want spousal support paid to you, you're going to mark respondent. Obviously, mark the box that applies to you if you're asking for support in a judgment. B is you are modifying a judgment for spousal support or partner support, and again to you. If you're the petitioner, mark petitioner. If you're the respondent, mark respondent. Let me say that again because I'm not sure exactly what I just said. If you're the petitioner, mark the petitioner. If you're the respondent, mark the respondent. All right, now, if you are asking the court to deny the request to modify a judgment for spousal support, and you're opposing it, you're the other side, and you don't want to pay it, for example, you're going to mark C. If you are asking the court to terminate jurisdiction to award spousal support to either the other party or both of you, you're going to mark D and then mark the appropriate box, petitioner or respondent. And the appropriate box is if you're asking to terminate jurisdiction to award your spouse spousal support, then if they're the respondent, mark respondent. If they're the petitioner, mark the petitioner. If you want the court to terminate spousal support to be payable to both of you, to either of you, then you can mark both boxes. Number two, attorney's fees and costs. I request that the court, and you check one, if you're asking for attorney's fees, if this form is being filled out as part of a request for attorney's fees, then you'll mark 2, and A says, order my attorney's fees and costs payable by my spouse or domestic partner. If you're asking the other party to pay for your attorney's fees, you're going to mark 2A and to A and the box next to my spouse or domestic partner. If you're asking for some joined party to pay, you would mark that box. That's very rare, and that's in case you have brought a motion and joined some other person or entity into your divorce case. That's very rare, and I can't imagine the situation in which they would have some other party paying for your attorney's fees. It could happen, but it's very rare, and if you're filling out your own paperwork, you're probably not in one of those more complex cases. If you are asking the court to not order attorney's fees, then you're going to mark 2B, deny the request for attorney's fees and costs. Okay? Now we're moving on to 3. Now, for the rest of this form, it's going to go through what are known as the 4320 factors, the Family Code section 4320 factors. And there's like 15, 16, 17 different factors. Some of them have sub-factors that the court must consider all of these factors before ordering long-term spousal support, permanent spousal support, or attorney's fees. So these boxes, they're a little bit of a pain in the neck to think about and fill out thoroughly. But if you want attorney's fees or if you want the court to give you permanent spousal support, you must fill this out and fill it out correctly. All right, and they are self-explanatory, but we'll go through them just so you know. 3A is Family Code section 4320A1. By the way, you can Google Family Code section 4320, and it'll give you a list of all the Family Code section 4320 factors. And you can follow that along in the law. It might be some interesting reading. It's really not a very long code, even though it looks like it might be. So just as an interesting thing, you might want to look that up. But they're all right here on the form. So 3A1 says the supported party, so that's the person that wants to receive spousal support, has the following training, job skills, and work history. Very common, and if you're asking for attorney's fees or if you're asking for spousal support, the party that's filling out this form might not have worked for many years. And if that's the case, you want to spell out everything. If you worked 18 years ago as a clerk, or if you worked 18 years ago as whatever it is, if you worked 18 years ago as a dentist, but you haven't worked in a while, you're going to put all of that in there and put some detail in there. And it's asking for your job skills, if you know how to use a computer, if you know how to type 70 words a minute, if you know, whatever you know how to do, that's where you put that stuff in there. And a work history. That's where you get to make sure the court understands that you haven't worked in 18 years. That's a big deal if you're asking for spousal support. Okay, number 2, the current job market for the skills of the supported party, described in 3A1, is, and then you want to make a list there of what the job opportunities are for you, keeping in mind your job skills. All right, number 3, the supported party would need the following time and expense to acquire the education or training to develop the job skills described in 3.1. All right, so if you need to go back to school to freshen up on or to relearn something so that you can go back into the job market, this is where you talk about that. And you talk about how much time it'll take and how much money it would cost to do it. Number 4, to develop other more marketable job skills or employment, the supported party would need the following retraining or education. So let's say, for example, you have no work history, or you had whatever you used to do has changed so much. For example, you were working in the computer industry, but you were working in the computer industry when computers were brand new. Completely different market. You would want to put that information into 4. and explain the training that you would need to develop some new education to get a job in the job market. All right, let me do this. All right, page 2. Again, at the top, you're going to list the petitioner and respondent. Again, those names never change. So if you're the petitioner, put it there. If you're the respondent, put your name there and the other party's name in the petitioner. Also going to list the case number to the right. All right, number 3, facts in support of request. Family Code section 4320A2. Provide any facts that indicate the supported party's earning ability is or is not lower than it might be if he or she had not had periods of unemployment because of the need to attend to domestic duties. Or what is this asking? This is saying if you're trying to get spousal support, in this box, you're going to want to explain to the court why you have large breaks in your work history if you were taking care of domestic duties. What does that mean? We had 3 children, and I didn't, from the first child we had, my husband and I agreed that I would not work and I would raise the children. You write that in there. If you had a husband and you or wife or whatever, and you as a couple decided that you would stay home as Mr. Mom and you would take care of the kids, put that in there. If you and she or you and your spouse agreed that you wouldn't work even though you didn't have kids, but it was an agreement that you would stay home and take care of the house and take care of your lifestyle and whatnot, then you would put that in there. And that's not uncommon. All right, so Family Code section 4320B, provide any facts that indicate that the supported party contributed to the education, training, career position, or license of the supporting party. Now, what does that mean? That means, did you, as the person that wants to receive support, did you support your spouse in their obtaining of an education or career opportunities that are now, that party is now reaping the benefits of? What does that mean? Did you take care of the children? Did you help, or did you use some of your own 401k monies, for example, to help put your spouse through law school or through dental school? Or while he got the education or she got the education to become an architect or something, and now they're making good money as a result of your assistance. If that is the case, that's where you mark that under 3C. And B, put some detail in there. 3D, the supporting party does or does not have the ability to pay spousal or domestic partner support. That's the supporting party. Does the other party have the money to pay you support? If so, this is where this goes. Number 2 asks, by the way, if they do have the money to pay you support, you're going to mark does. You're going to have a hard time getting spousal support or attorney's fees from the other party if you mark does not have the money for it. Okay, 2 says the supporting party's current gross income from employment or self-employment is, and put it in there. If you don't know what it is, you better put your best estimate, and it better be very close. And they're going to want to know, how do you know that information? So seek it out, get that information, put it in there. They're also asking the supporting party, that's the payor, that's the person you want to pay you support, the supporting party's current income from investments, retirements, or other sources is, and put that information in there. If it's $1,800 a month, put that in there. D4, the supporting party's current assets and their values and balances are. Now, if you're married or if you're asking for support or for attorney's fees from the other side, this big box there, that's where you list all of their assets, or as many assets as you know, and the values that you believe those assets are. If they own 2 houses, definitely put that in there. If they've got a 401k worth $226,000, definitely put that in there. If they've got a bank account with $13,000 cash sitting in it, put that in there. And if you have a copy of that bank statement that they have, attach it to this form to show that money exists and that it's actually liquid and available right now. If it's got a Social Security number on it, black that out. Anytime there's a Social Security number on any forms, black it out. You're not allowed to file a form with the court with a Social Security number on it. Okay. So that's where all that information goes. 5, the supporting parties. You need to understand, so the supporting party is the person that's paying the support. The supported party is the person that wants to receive support. So the supporting party's standard of living is, and you're going to describe that below. So you want to type in what kind of vacations they take, how often they take vacations, what kind of cars they drive, if they go out to eat 3 or 4 nights a week, what kind of restaurants they go to. Are they spending, $8 at McDonald's, or are they spending, $80 for a meal each at a very high-end restaurant? You want to put that in here. You want to talk about their investments and how much they save per month to put into investments. Anything you can put in here to describe what kind of lifestyle they live. Okay, top of the next page. Again, petitioner and respondent and the case number. 3, facts and support of request, Family Code Section 4320D. The supported party, that's the person that wants to receive support, does or does not need support to maintain the standard of living we enjoyed during the marriage and or domestic partnership. Obviously, if you want to receive support, you're going to mark does. Under 3F, it asks for the supported party's assets and obligations, including separate property, are. This is where you list your assets and obligations, debts too. Next section, the supporting party, the other party's assets and obligations, including separate property, are, and you're going to put that in there. Let me see how that's different real quickly then. Okay, so in the box before D4, this is where you're listing their current assets and the values and balances. Under 3F, 3F2, the supporting party's assets and obligations. This is basically a reprint of what you put in that other box. And they're also asking for a list of values and balances. I would write the exact same thing you wrote in the other box, write it again in this box. All right, next page. We are on page 4 at the top. Okay, so facts in support of request, Family Code Section 4320F. It's asking, under G there, it's asking for the length of marriage or domestic partnership. In this form, I've put 14 and 3. I would go further and put 14 years and 3 months. That's what that stood for. Just so you know, that information was in the software in a different question, and it preloaded that automatically for me. So that's what you want to put in there, the length of marriage. So if it was 10 years, 9 months, or 26 years and 2 months, whatever it is, put that in there. Okay? H, provide any facts indicating whether or not the supported party, you, is able to work without unduly interfering with the interests of the children in his or her care. So, provide any facts indicating whether or not the supported party is able to work without unduly interfering. If you've got small kids and you go to work full time, you're going to interfere with the taking care of little kids. If you've got a 14-year-old, a 16-year-old, and a 17-year-old, and they're all in high school, and they get up in the morning and make their own breakfast, and they make their own lunch, and they ride their bike to school or walk to school, and they get themselves home, and they're able to do their own homework until you get home from work, you can go to work without unduly interfering with the interests of the children. It's just kind of how it goes. If you have a child with special needs who's 17 years old and they can't take care of themselves, then take that into consideration. I, the petitioner's ages, simply put in the petitioner's age. Respondent's age, simply put in the respondent's age there to the right. Petitioner's current health condition is, if you're both healthy, put healthy. If one of you has lupus and scleroderma and some other disconnective tissue disease or cancer, or you're going through treatments of some kind, or diabetes, you're going to list those ailments in there for the appropriate person. Petitioner under 2, respondent under 3. If there are no problems and everybody's healthy, just put healthy, healthy, and move on to J. J reads, the court will also consider the following factors before making a judgment for spousal or domestic partner support. 1, any documented evidence of domestic violence between the parties as defined in Family Code Section 6211. 6211 just describes what domestic violence is. If you have called the police, it needs to be documented. Notice it says documented evidence of domestic violence. If there was an arrest, a domestic violence arrest, clearly that is documented evidence. Is it documented evidence if you can get proof of calling the police on some form of a call log, and they just fill out a field interrogation card and you can get a copy of that, but they never wrote a real report? I would suggest that that is documentation of some kind of domestic violence. But whatever you've got, if you've got some domestic violence, is a factor in ordering spousal support. 2, the immediate and specific, let me go back for a second because something just popped into my head. If you have committed domestic violence against your spouse, if you were the aggressor and you were arrested and there's conviction against you for domestic violence against your spouse, you need to understand that there is a presumption in the law that you shall not receive spousal support. They don't want the victim of spousal support to have to pay spousal support to their aggressor, to the person that was committing domestic violence against them. Keep that in mind. Number 2, the immediate and specific tax consequences for each party. If you know of any immediate and specific tax consequences with regard to paying support or attorney's fees, put it in there. If you don't know any, put unknown or none. 3, the balance of the hardships for each party. They're asking you to explain what the balance of hardships would be if you did or did not receive spousal support. Is the others, for example, if the other side, if you were a stay-at-home parent and your spouse is a doctor, works 60 hours a week, not uncommon, and brings home $350,000 a year, they're going to have a hard time saying that there's any hardships on that side to paying support to you. You, on the other side, if you do not receive spousal support, how would you pay for any bills? You have no income. How would you pay for your cell phone? How would you pay for food? How would you take care of your children if you have children? These are the kind of things you're talking about. 4, the criminal conviction of an abusive spouse in reducing or eliminating support in accordance with Family Code Section 4325. So this is what I was talking about. If there's criminal convictions of abuse in your marriage, you're going to, and it's against you, you may not get any spousal support because of that. If it's against the other party, definitely attach it to this paperwork and explain it here in this big box. 5, the goal that the supported party will be self-supporting within a reasonable period of time. Just so you know, that's standard language that is involved in most judgments, most cases. It's basically just saying you need to understand that within a reasonable amount of time, the supported party should figure out a way to support themselves. Now, if you were married for 32 years and you're 74 years old and you're getting divorced, you're not going to have to go to work. I mean, if you're super healthy and you've been working, you're not allowed, they would, they're going to hold you to a different standard than they would a 35-year-old spouse who's getting divorced and has working job skills and just hasn't worked for 2 years, but could definitely go get work, and they were only married for a couple years. They're going to have to go back to work relatively soon. You got a lot of leeway if you were married for 20, 30 years and have been not working that entire time, and your spouse has been supporting you that entire time. Okay, 6. Any other factors the court determines that are just and equitable. That's a catch-all. If you've got any other factors that you want to tell the judge, this is where you can put them. By the way, real quickly, if you have a lot to write on these 6 different factors and you don't have enough room in that box, take a regular lined sheet of paper and put attachment J, let's call it attachment 4320J. And then you can put, and just be specific about what you're adding to here. If you're adding to number 2, put a 2 in front of it. If you're adding to 4, put a 4 in front of it. All right, folks. That is the extent of the FL-157. Again, this form is used for many different things, and if you're watching it in a string of videos, obviously you need it for what you're working on. So this is a difficult form. It's a time-consuming form. It requires a great deal of detail. Be specific. You're asking the judge to give you attorney's fees or to give you spousal support. If this form is not done completely, or it just looks like you're doing a half-assed job of putting it together, you may not get any help financially. So do it right, folks. Do it right. Again, my name is Doug Pinkham. I hope this video has been helpful for you. Thank you very much for listening.